Key definitions in Digital Personal Data Protection Bill 2023. Yes, India passed its Digital Personal Data Protection Bill, and now it's time to understand the key definitions. Let's do that in this video. Hello and welcome. My name is Punit Bhatia, and in this video, we are going to talk about the key definitions in context of Digital Personal Data Protection Bill 2023 of India. Yes, this has been the most talked about law in recent times, and I'm going to talk about the key definitions. And of course, in the next video, I will talk about the key requirements. So today, we talk about the key definitions, and then in the next one, we talk about key requirements. Now, when we talk about key definitions or key terms, I'm going to simplify these into different terms or definitions. It may seem that this bill is similar to EU GDPR. Yes, there are similarities. Yes, it is inspired by EU GDPR, but it is a different law, it's a different bill, and hence some of the definitions are very, very different. So let's start with the 12 key definitions or terms in this law. So the first key definition or key term is data principal. Data principal is same as the EU GDPR data subject, and it means the individual whose personal data is being processed. It can be a child, it can be the lawful guardian, that is the parents, or if it's a person with disability, the lawful guardian acting on his or her behalf. The second definition or second term is the child. Who is a child? So compared to the EU GDPR, wherein there is flexibility for member states to define the age for children between 13 and 16, here in the Digital Personal Data Protection Bill of India, the lawful age for children is anyone below the age of 18. So anyone who's below the age of 18 is considered a child. Now the third key definition is that of a data fiduciary. Now it's similar to what we call data controller in the EU GDPR. I don't know why they chose a different term, but it is a company that is determining the purpose and means of processing of personal data. Now, in this case, they do use the term that the company may do it alone or in conjunction, but there's no further reference of joint fiduciaries. And another important aspect here is they do not refer to data fiduciaries as entities, as in GDPR, they refer to it as persons. So what is a person? I'll come to that in a moment. But before that, let's go to the fourth key term or key definition, that is of a data processor. Thankfully, data processor is same as that of the EU GDPR, that is any person who processes personal data on behalf of a data fiduciary. So no change here. Now, as I talked about in context of the data fiduciary, they use the term person rather than a legal entity, and they define this term, the fifth key definition, person, as anyone who is an individual, Hindu undivided family, a company, a firm, or even an association of person or body of individuals, whether incorporated or not. And also they say that any artificial juristic person not falling in any of the above categories is also a person. This is a bit confusing. I think we will get some clarity on this part as we go along. But in short, the fifth is the person, which is same as what we used to refer the legal entity in EU GDPR context. So when we are referring to data processor, data fiduciary, or any other entity, we will be referring to in the Data Protection Bill of India as person. Now the sixth important key definition is the data protection officer, which means the individual who has been appointed as the person from data fiduciary. Here there's a slight differentiation from EU GDPR. One, not all data fiduciaries have to appoint a data protection officer. Only the significant data fiduciaries have to appoint a data protection officer or a DPO. Now, how do you determine a significant data fiduciary? That's a little bit something that will get clarified over the years, but right now it says the DPDP Act, so the Digital Personal Data Protection Act or bill, empowers the government to designate any fiduciary or class of data fiduciaries, so even a set of companies, as significant data fiduciary, which is done based on certain criteria. And then when these criteria are applied, they will also have additional processing obligations, including those of appointing a data protection officer. If you want to understand what are those additional requirements for significant data fiduciaries, that we will talk about in the requirements or key requirements video relating to Digital Personal Data Protection Bill. For now, there is a data protection officer, that is a key definition. Now, we talked about 6 so far. The 7th one is personal data. Thankfully, very similar to what we have in EU GDPR, that is, personal data is any data about an individual who is identifiable by or in relation to such data. Simple and straightforward, but with caveat, there is no special categories or sensitive personal data, only personal data, which in a way has its advantage in terms of implementation. But I think having special categories of data allows for special measures, special protection for that. For example, health or religious beliefs or political affiliation. But in the Digital Personal Data Protection Bill, that is not the case, only personal data. So that was the 7th key definition, and the 8th one is a personal data breach. Similar to EU GDPR, any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data is a data breach. Also, you can say anything that compromises confidentiality, integrity, or availability of personal data. No significant difference, just personal data breach. The 9th one is processing. Again, processing is about operation or set of operations performed on digital data, such as collection, recording, organization, structuring, storage, adaptation, alteration, retrieval, use, alignment, combination, and so on and so forth. What I call it is any operation performed on personal data is processing. Yes, in my opinion, anything you do with personal data, that is called processing, and that is our 9th key definition. The 10th one is public interest. Yes, in this law, there's a lot of talk about personal data, but there's a lot of talk about public interest as well. And there are a lot of exemptions to that regard. So public interest is defined as any interest in any of the following, that is sovereignty and integrity of India, security of the state, friendly relations with foreign states, maintenance of public order, preventing incitement to commission of any offense relating to proceeding clauses, even prevention and dissemination of false statements or facts. Now, essentially, what you need to understand about public interest is elements or aspects or activities that lead to security and other threats in context of state, and those are eventually considered as exemptions or referred as public interest. That was the 10th key definition, and now the 11th key definition is what we call consent manager. Now, this is new. This is not there in the EU GDPR. That is a person registered with the board. So person, remember, it's not individual. Person is an entity, a company, a undivided Hindu family, and so on and so forth, who acts as a single point on behalf of the data principal or on behalf of the data fiduciary to enable the data principal to give, manage, review, and withdraw their consent through an accessible, transparent, or interoperable platform. I think what they are setting the stage is for data brokers or representatives of data fiduciaries. That's my guess on consent manager. But as new guidance comes along, as they implement it, we will get more clarity. But for now, consent manager is a key term, key definition to be understood. That is the 11th one. And now the 12th one. The 12th one is the digital office. Yes, this is a term being used, which means an office that adopts an online mechanism wherein the proceedings from receipt of complaint, intimation, reference, or directions or appeal are thereof conducted in digital or online mode. I consider this more as a privacy office, but maybe with AI and new acts that will come up, they're setting up a digital office which will take care of privacy, AI, and probably other things. But for now, in context of the Personal Data Protection Bill or Digital Personal Data Protection Bill, it is a digital office that companies would eventually be setting up. Now, those were the 12 key requirements. And if you noticed a few things, there was no definition for or no term called sensitive or special categories of data. That is only personal data. And there's a lot of focus on digital, like they talked about digital office, which to me is kind of a privacy office, but they have broader scope in their mind. Then the name of the law is also Digital Personal Data Protection Act. So it's not applicable on non-digital data. And this is going to be very interesting. But be aware that if you collect data in non-digital format and then later on convert it into digital format, that is still in the purview of the law. So some interesting things and some new things, if I may call it like that. So, in short, we talked about 12 different terms, starting with data principal, same as data subject, child, who is someone who has not completed 18 years of age, data fiduciary, which is similar as the data controller in GDPR, data processor, same as EU GDPR, then the person, which is more of a individual or a company or a legal entity, and then the data protection officer. We also talked about the personal data, same as EU GDPR, personal data breach, which is also EU GDPR similar, processing anything you do with the data, public interest, more for the perspective of exemptions, and then consent manager, which is a new term. They use it from the perspective of, I think, intermediaries or third parties or brokers as they will come along, and the digital office, which is going to be a good privacy office kind of a role. So, with that, I would say thank you so much for watching. I hope it was useful. And for those of you who are watching me for the first time, my name is Punit Bhatia, and I help companies and executives understand and manage privacy risks by defining and implementing strategies for compliance with privacy and AI laws. If you like this video, share it with a friend, click like, make a comment, and subscribe to our channel. And if you've already done so, thank you so much. Goodbye for now and keep protecting data.